Hi, I'm Nick Nanovic, and I'm here to talk about trust busting. When putting together your estate plan, it's very common to incorporate a trust as part of that plan. In many cases, it makes sense to have a trust to protect that inheritance for the beneficiary that you intend to receive those funds. But what happens when that trust no longer makes sense? If you fund the trust, if it becomes irrevocable at some point, but then at some point in the future, the beneficiaries or you yourself no longer want that trust to be in place. Even though the trust is irrevocable, there are opportunities to bust that trust open, to either modify it or completely terminate and distribute the assets to the intended beneficiaries. The situations under which you can do this vary depending on the circumstances. For example, if you, the creator, are still alive, there are certain options that you have available to you with the consent of all the beneficiaries to modify or terminate the trust. If this occurs after you have passed and you, the creator of this trust, are no longer alive, there are still options for the trustee and the beneficiaries to modify or terminate the trust, but they become more difficult. Depending on the circumstances, you can either have what's called a non-judicial settlement agreement among many of the parties that are involved, or there may be circumstances where you need to go to court and a judge will review the matter and decide whether it is necessary at that point in time to either modify or terminate the trust. The key thing is the understanding what the circumstances are, and under those circumstances at that time, what your options are and what may make the most sense. If you have any interest in how to modify or terminate a trust or otherwise general estate planning, feel free to contact me or any other attorney at Gross McGinley, and we'd be happy to help you.